right, it is 12:01, so why don't we go ahead and get started? Welcome, everyone, and thank you for joining the Pennsylvania Human Relations Commission's Fair Housing and Power Hour session on utilities and housing. So today we are excited to host our guest presenter, Lauren Berman, Senior Staff Attorney at the Pennsylvania Utility Law Project. My name is Brittany Mellinger, and I'm the Director of Fair Housing and Commercial Property at the PHRC, and I'll be your host here today. So before I do a full introduction for our guest speaker, I want to share some logistical details and share out some background on PHRC's housing work. So first, I do want to let you know that today's session is being recorded, and our recording and session and slides will be sent out today after our program. So I'm going to put into the chat a statement about our recording. So it is against the law in Pennsylvania to record oral conversations without the permission of the folks involved in most circumstances. And the session is being recorded for training and/or record-keeping purposes. By participating in the session, you are consenting to the recording, retention, and use of this session. If at any point you have a question or a comment, please feel free to put that in the chat, and we will respond to you as soon as possible. If you would like to ask your question or to comment verbally, please note that by doing so, you are consenting to the recording, retention, and use of your statements. Recorded as part of the session. And if you have any questions about this, please let us know. So we will be inviting you to put any questions that you have over the course of the presentation in the Q&A box. And we will be periodically checking that and addressing any questions throughout the course of the presentation. And we'll also hold a little time at the end for any additional questions or comments that you might have. Before we jump into today's topic, I do want to provide you a brief overview of the PHRC and our housing work for anyone who's not familiar with us. So we all have the right to fair housing in Pennsylvania, and that's so crucial because of what housing means for us in terms of the opportunities it presents, our access to clean air and clean water and transportation and jobs, and where you live matters. So it matters that we all have equal access and opportunity to housing. A quick engagement acknowledgement. Information materials and/or technical assistance are solely intended as informal guidance, and neither are a determination of your legal rights or responsibilities under the PHRA and/or applicable federal laws, nor binding on any agency with enforcement responsibility under those same laws. So the Pennsylvania Human Relations Commission is the leading civil rights enforcement agency in Pennsylvania. We exist to make sure that Pennsylvanians can live, work, and learn free from unlawful discrimination. We have a two-part mission. We both enforce Pennsylvania's non-discrimination laws, including both the Pennsylvania Human Relations Act as well as the Pennsylvania Fair Educational Opportunities Act. So we accept complaints when folks believe that they've experienced discrimination, but we also work to proactively promote equal opportunity for everyone in Pennsylvania. We host trainings and events and education like this, and we've got active advisory councils and other ways for you to get involved in our work as well. Under the Pennsylvania Human Relations Act, that has protections under employment, housing, commercial property, public accommodations, the ability to access public businesses and services, as well as primary and secondary education up through high school. And the Pennsylvania Fair Educational Opportunities Act extends that coverage into post-secondary education, such as colleges, trade schools, and technical schools. In housing, we have protected classes, so groups of individuals who have protections under our laws. Under the Pennsylvania Human Relations Act, that includes race, color, national origin, ancestry, age 40 and above, familial status, so the presence of children in a family, sex, religion, disability, as well as the use, handling, or training of support animals for disability. So when we talk about fair housing and protections against discrimination, I want to provide you a kind of a brief overview on what discriminatory actions can look like. It's anything from discriminatory statements and advertisements in conversation, discriminatory inquiries while someone is looking to rent or buy a home, steering to a specific neighborhood or a specific type of housing, refusal to sell, lease, or finance housing, unfair appraisals based on someone's protected class, predatory lending practices, discriminating in housing terms and conditions. So the terms of the lease, it could potentially involve the way that utilities are provided, unequal provision of services and facilities in housing, sexual harassment, as well as refusal to provide reasonable accommodations or modifications for individuals with disabilities who need those changes in order to use and enjoy their housing. So fair housing has two goals: ending housing discrimination, ensuring that no one is kept out of housing opportunities because of their identity through discriminatory practices and policies, but also goal number two, promoting diverse, inclusive communities, which is known as affirmatively furthering fair housing. So we put a strong emphasis on ensuring fair housing choice in Pennsylvania, which involves having actual choice, the existence of realistic housing opportunities, protected choice, that's housing that can be accessed without discrimination, as well as enabled choice. So that's realistic access to sufficient information regarding options so that any choice is informed. If you've attended a Fair Housing and Power Hour session in the past, you'll know that our format is typically one of our staff members presenting on a specific fair housing topic, such as reasonable accommodations or familial status discrimination. In 2026, we're changing it up a little bit. So in February, we released an updated version of PHRC's white paper, The State of Fair Housing in the Commonwealth of Pennsylvania. I'm going to put the link to that report in the chat in case you have not had a chance to view that. So as we're looking to advance these goals of fair housing, ensuring that we have actual choice, protected choice, and enabled choice in housing, we are taking a broader look at housing opportunities in Pennsylvania from a fair housing lens. So how do our housing shortfalls and inadequacies impact individuals in protected classes, and what actions can we take to expand fair housing opportunities? We're inviting guest speakers to join us for our Fair Housing and Power Hour series to go into greater depth about groups of individuals at risk of discrimination and to highlight specific issues and concerns that impact access and opportunity to housing. When we look at housing affordability, which is a key barrier for individuals in accessing housing, the cost of the rent or the mortgage is really just one part of the equation. The cost of utilities can significantly vary based on the type, size, and age of housing, and Pennsylvania has some of the oldest housing stock in the nation, which can lead to increased utility costs. We're at a time with rising energy costs and uncertainty about how so many of our local and global changes can impact our bottom line. So it's more important than ever to understand how our utilities work in Pennsylvania and what tenants and landlords can both do to navigate these issues. And we've brought in a great speaker to address that. Having worked in fair housing in southwestern Pennsylvania, Lauren Berman currently serves as a senior staff attorney at the Pennsylvania Utility Law Project. She primarily works in direct representation of low-income Pennsylvanians and enjoys providing trainings, webinars, and other technical assistance for organizations that provide services to low-income households. When not representing individuals or providing trainings, Lauren assists on complex litigation cases and policy matters. So welcome, Lauren, and thanks for joining us today.
Thank you so much, Brittany, and thanks for that great introduction. I think you summed up really well why utilities matter to housing. And yes, I used to work in the fair housing world, so I'm always happy to get to interact with my PHRC folks again. That was also with legal aid. So I'm going to go. Are you okay for me to share my screen now, Brittany?
Yes, please go ahead.
Okay, great. Okay, thank you. So let me get this shared and started, and we will go from there. Okay, great. So, as Brittany said, my name is Lauren Berman. I'm a senior staff attorney with the Pennsylvania Utility Law Project. We are part of legal aid. So like your local legal aids, mid-pen, neighborhood legal, we're part of that same statewide network, but we are a little bit different because we are statewide. So we address basically utility issues that arise in the state of Pennsylvania. Our mission is to secure just and equitable access to safe and affordable utility services for Pennsylvanians experiencing poverty. And we do this in a bunch of different ways. So we do legal representation. So like Brittany said, I represent individuals who are struggling to either get connected to service, stay connected to service. We also are involved in complex litigation cases on behalf of group clients. So basically, whenever a utility company wants to raise their rates, they have to file with the Public Utility Commission and explain why. We intervene in nearly all of those proceedings, and we, are typically fighting against the rate increases. It's particularly like the size of the rate increases, and also making sure that if any rate increase does get approved, that there are comparable enhancements, adjustments to the existing low-income programming to try to keep people, again, connected to service that they need to live. We also do education and training like this. We can do policy advocacy, so we do lobby at the state level. We also provide supportive services, so, other proper referrals and consultation. So, for those of you that are advocates that represent people individually, if you have questions about utilities, we are a good place to reach out to for technical assistance, and we'll make sure you have the contact information for us. Just a brief overview. So like I said, we are part of the Pennsylvania Legal Aid Network. So you can see, depending on what county you're in, every county has a designated local legal aid. Your first call for utility matters for consumers is going to be your local legal aid. We do a lot of training for them. So, they should be able to handle a lot of the simpler things for you, depending on capacity. I know everyone, I'm sure everyone is understaffed and overworked, because that is just how this goes. But your first referral for someone that you're trying to help, or for you help yourself, is going to be one of your local legal aid offices. So I'm going to give a brief introduction on sort of the landscape of utilities in Pennsylvania. We're going to talk about consumer protections that apply to all customers, not just tenants. And then we're going to talk about some specific tenants' rights. That last one, shopping and suppliers, I did actually remove those slides, and I forgot to update the agenda. So we're going to skip that unless we have time at the end. I'll circle back. But there's a lot to cover, so I didn't want to overload us. We're going to talk about the existing assistance programs, how to get connected to those, and then some specific referrals and resources. And like Brittany said, if you have questions as we go, please feel free to just put them in the Q&A, and I'll give a pause at the end of every section to address anything that came up. And then if you guys want to ask questions at the end, that's completely fine. Hopefully we'll have some time. So as an introduction, here's just a snapshot of what we're actually dealing with when we talk about, the struggle to stay connected to services, and the way, electric specifically has become very, very expensive recently. Not just recently, but it's getting more expensive. So in 2020, 27% of households in the US were experiencing energy insecurity. That means, not necessarily not being able to pay your bills on time. It means trading. Maybe you pay the electric bill and you skip a prescription pickup, that kind of thing. It's not just getting disconnected. It's what are you having to sacrifice in order to stay connected? Nearly 25% of households reported reducing or foregoing food or medicine to pay energy bills. Energy insecurity disproportionately impacts households of color. Native American and Black households report insecurity at nearly twice the national average. That does tie back. I mean, it is basically, when you're talking about fair housing and you're talking about sort of the legacy of redlining, this just falls under that category, essentially. Sorry, it's my dog's in the back. But so anything that you see, with sort of disproportionate impacts to neighborhoods, disinvestment, all of those things apply to utility services as well. In Pennsylvania specifically, 1 in 20 households have a utility debt with average balances exceeding $1,200. So that's not one missed bill. That is a sort of a continuing struggle to maintain services. And in 2025, this is Pennsylvania, mind you, over 400,000 families had their electric, gas, or water services terminated. There's probably some overlap there, right? Because if you're struggling with one bill, you're probably struggling with the other bills too. That is a huge number of people. Since 2022, involuntary gas and electric shutoffs have increased in Pennsylvania by 27%. Each year has been worse than the one before. This is a pervasive problem. Some of the consequences of utility insecurity are very similar to the problems with housing insecurity, right? So exacerbating negative health outcomes, exposure to unhealthy or unsafe temperatures, either too cold or too hot. Heat is going to be an increasing problem in Pennsylvania. inability to properly sanitize. Of course, we all, COVID, we know how important water is. Family, it interrupts family unity, can hinder child learning and development, especially for people who are either doing cyber school or people who are in a hybrid situation. If the electric is off, they can't work, they can't go to school. Long-term impact on consumer credit, certainly. Housing absolutely can be a catalyst for eviction, foreclosure, and homelessness. In most lease terms, you are required as the tenant to be able to maintain utility service. If you cannot do that, you may be in violation of your lease and may be up for eviction. We do also see constructive evictions. So occasionally landlords turning service off, like physically turning service off at the breaker box or something like that as a self-help eviction. That can result in condemnation, of course, difficulty relocating to new housing, and ineligibility for public and private housing. We do see this where a person may be otherwise qualified. Let's say they have a Section 8 voucher, they found a place, they're otherwise good to go. But if they have a debt from a previous location, from the gas company, the water company, the electric company, that can absolutely prevent them from moving into that new housing. So in Pennsylvania, our regulatory structure kind of divides utility service providers into two big chunks. So you have the Pennsylvania Public Utility Commission regulated utilities. So that's First Energy, Columbia Gas, Duquesne, PECO. It's most of the large electric, natural gas, and water companies. So Aqua PA and PA American. They are under the jurisdiction of the Public Utility Commission. When you have a complaint, there's a fairly straightforward complaint process. It's actually somewhat similar to the PHRC complaint process. Those are sort of corollary state agencies. And there are very specific rules that they have to follow for billing, collections, and terminations. And there are very specific assistance programs that they have to offer. Electric and gas are a little bit different, but the regulated water does have basically comparable programs. And then on the other side, you have basically everyone else. So for the exception of PGW, which is the gas company in Philly, and Pittsburgh Water, which is our water company here in Pittsburgh, and then there are a few electric co-ops, that municipal utilities and electric co-ops are not covered under the Public Utility Commission. So if you are having an issue with your borough sewer or your city water, that is not going to be something that the commission can handle. And honestly, it's not really something that we tend to get involved in, only because they don't have the same requirement to negotiate and work with the customer as the regulated utility companies do. That doesn't mean there's no recourse or there's no rules. There are rules. They just aren't as specific, and they're a little more difficult to access. So if you have a complaint, you have to go through the regular court system. You file a complaint with the Court of Common Pleas. There are protections for tenants. We'll talk about that. Whereas you can't be held responsible for the water debt of a previous tenant or a landlord. And then there are, no billing, collections, and termination standards, so they don't have to bill the same way. A lot of boroughs will bill water quarterly. That's completely allowed. And there's no requirement for assistance programs or any kind of payment arrangements. Some have their own policies that they will do that. So it's not that they can't, but they do not have to. Any questions on that before we move on to some specific consumer protections? Okay, I'm going to assume no, and I'm going to keep going. Great. So key consumer utility protections. So we're going to talk about security deposits, the winter moratorium, medical certificates, specific protections for survivors of domestic violence, and what the rules are around payment arrangements and disputes. And so these are going to apply to customers of the public utility company. So anyone that's covered under the Public Utility Commission, that sort of category, all of this applies to them. And unless I specifically mention, it applies equally to tenants and to homeowners. So for security deposits, companies can absolutely charge you a security deposit. They can be up to 1/6, so 2 months worth of the estimated annual bill of the place that you're moving into, right? So it can be up depending on what the bills were at the place you're trying to move into. That can determine how much they can charge you for a security deposit. They do have to provide up to 90 days to actually pay it. And basically they split it up over the first 3 bills. So you'll pay half of it on the first bill, and then a quarter of it on the second bill, a quarter of it on the third bill. However, the exception to this is if a customer has income of at or below 150% of the federal poverty level, which is pretty low, but that's the same income limit for LIHEAP, that's the same income limit for the CAP programs we're going to talk about in a little bit. They cannot charge a security deposit to those customers. So you don't have to enroll in the discount program, but you do have to prove your income eligibility, which essentially means providing your income information, whether that's an SSI award letter, whether it's your pay stubs, whatever it is. When you're calling to set up service, if you are at or below that 150% of federal poverty, it is in your best interest to make sure that the utility company knows that and ask them how to best get your income information to them so that you're not charged a security deposit. If you have been charged one previously, either they did it in error or your income changed, the utility company has to refund that to you. So if you are currently at or below 150% of federal poverty and you think you paid a security deposit, it is absolutely worth a phone call to your utility company just to double check, because if you are income qualified, they have to give that back to you. And the winter moratorium. So this has somewhat recently ended, but the winter moratorium runs every year from December 1 to March 31. It applies again to just the PUC regulated gas, electric, and heat related water service. So for example, you see I have a radiator, so I need my gas, I need my electric, and I need my water in order to have heat. I need all of those. So if I were income eligible, that I would be protected under that moratorium for all of those services, assuming they were all from regulated utility companies. And that income limit is 250% of federal poverty or below, so significantly higher than for the discount programs. It is a broader protection. The utility has to know that you are low income, which is, again, communication. I'm going to come back to this a lot. Communication with utility companies is really important. It's better to over communicate than under communicate. So I always recommend that people, if they think they're somewhat around that range or should have some of those protections, make sure the utility company has your current income on file. And bills do continue to accrue. So, you will not get shut off because that is a harm reduction, right? We don't want anyone freezing to death, but it doesn't do anything about the bills. If you're not able to pay over the winter, those bills are going to become due in the spring. If the service is off on like November 25th, that doesn't mean they're going to turn you right back on December 1st. You're going to have to figure out, how to get on otherwise. But if you do get shut off during the moratorium because maybe they didn't have your income information on file or it was just an error, they should restore you immediately, and then give you till the end of the moratorium and sort of do the regular thing. So the utilities do typically start sending out shutoff notices as early as February, since they're good for 60 days. And that does allow eligible clients to apply for LIHEAP grants before the moratorium ends. This year, LIHEAP ran until May 8th, which was nice. It got extended a couple of weeks. So people had a few weeks between the end of the moratorium and the end of LIHEAP to try to address those arrears that sort of built up over the winter. Medical certificates. We get these questions a lot. The medical certificate protections are probably not as extensive as we think they should. I mean, I know that's for me. They're not as extensive as we would want them to be. But what the protections are, basically a household can obtain a medical certificate to delay termination if a household member has a serious illness or a medical condition which requires utility service. So it could be someone that requires oxygen, a CPAP machine. It could be someone that has medication like insulin that needs to be refrigerated. Any of those, should qualify, but it's a broad umbrella. It's not specific. And the medical professional, not the utility, gets to decide which conditions qualify. So the form is very straightforward. It does not require a diagnosis to be provided to the utility company. That is your personal medical information. The utility company does not need to know that. All they need to know is that your doctor has signed the form and submitted it. That's it. The medical certificate will stop termination for up to 30 days from the date of issuance. If you are on with the medical certificate, you got one to delay a shut off or to prevent a shut off, and you are able to pay your current charges. So that's not the past due, but that's whatever your bill is from your usage in that last 30 days. Or if you're on budget billing, it's whatever that amount is. If you're enrolled in a discount program, it's whatever that amount is. If you're able to pay that in full on time while you're on with the medical certificate, you can continue to renew that medical certificate for as long as you can do that. Sometimes that's a fight with the utility company because most people aren't able to do that. And so I don't, I run into clients all the time that said, oh, well, that's not what they told me. They may not tell you that because it's hard to do. Like if you were able to pay your current charges in full on time, every month, you would not have needed a medical certificate to order to prevent a termination. So it's a very difficult thing to do realistically, but that is the rule. If you're not able to pay anything or you're not able to pay the full amount while you're on, you can still renew the medical certificate 2 more times, and that gives you a total of 90 days of protection. But then that's it. Once you use those, that is all you get for the household, for the account until the underlying debt is paid off completely. So that is where we run into issues. If you have been carrying a debt for years, which a lot of people do, bills are very expensive, if you've had a medical crisis a couple of years ago and you needed those protections, you can't have them again unless the entire debt is paid off on the account. So limited protection. We did provide a link to the template. Some of the utility companies use their own, but they will all accept the template one from the commission. It's all the same information. So some specific protections for survivors of domestic violence. Again, this is another thing where communication with the utility company is very important. These protections really only apply if the company has a copy of your PFA or other court order on file. I will say this is a great opportunity for advocacy. The utility companies have been fairly flexible with us on what kind of documentation they will accept. Sometimes they'll accept the victim advocate statement. We know there's a lot of reasons that people do not pursue a PFA. So they can be pretty flexible, but they're going to need something showing what actually happened. So it's a good opportunity for some advocacy. The survivor cannot be held responsible for debt accrued in anyone else's name, even if they lived at the residence when the debt accrued. So basically the rule for absent this protection, if you are an adult in a household when the debt was accruing, the utility company can hold you responsible for it, even if the service was not in your name. So this comes up a lot, but it's called occupant liability, and it is the rule in Pennsylvania. So this is an exception to that rule. Flexible payment arrangements, again, they do have to offer based on individual facts and circumstances. Typically it's 60 months, which is 5 years. It's possible to get longer than that, again, depending on the circumstances. But again, they should be willing to work with you. They do have specific customer service reps that are trained to deal with these types of situations specifically, but if you do need help getting in touch with the correct person, that's absolutely something that we can help you with. Additional protections are attempted personal contact immediately preceding termination. And again, without this protection, they come, they knock on the door and shut you off. If your account is noted that you are a victim of domestic violence, then notice is posted to the property at that point, and then it's an additional 48 hours before they can actually terminate you. So payment arrangements. A lot of people are on payment arrangements. Not everyone is clear on what the terms of those are, because I don't feel that those get explained particularly well, but payment arrangements are certainly an option if someone falls behind and cannot enroll in a discount program, and we'll talk about those sort of at the end. But essentially agreeing to a payment arrangement means that the client has accepted that they owe that amount to the utility. You're saying, yep, this is my debt. Let's spread it out. So typically it'll get spread out between 6 or 60 months, depending on circumstances. There are some rules around income and how much they're going to offer, how long they're going to offer you, depending on your household income. Typically, you're going to get 1, maybe 2 from the utility company. And after that, they're just going to say, nope, sorry, you fell behind, and so no more. The installment amount is always going to be in addition to the regular monthly bill. And that is what makes these tricky. is because if you've fallen behind on your current bills, you are now agreeing to pay your current bill plus an additional amount, which can be incredibly difficult. And we will talk about some weatherization programs, but oftentimes we see this with people who are above the income limit for the discount programs, but have very high usage, either because it's an old house, it's all electric heat is very expensive, or they have a gas furnace that isn't working appropriately or isn't working at all, and so they're relying on space heaters. Those are hugely expensive. We absolutely saw 4-figure bills over the winter, January, February, for people who had to rely on space heaters because it was very, very cold for a very long time. So I absolutely had clients that were getting bills for $1,100, $1,200 a month. Utility issued payment arrangements, again, they can do as many as they want for as long as they want, but they don't have to. So again, this is a great opportunity for advocacy. We do have luck sort of renegotiating, especially if someone has made some payments but fell behind or wasn't able to make full payments. We have had some luck negotiating with the utility companies and getting people on a payment arrangement that is reasonable for them, is reasonably affordable for them. But that is not always possible depending on what the underlying usage is. Because again, you always are going to have to pay that regular monthly bill, and it's just going to be something on top of it. So if you've already had a couple of payment arrangements with the utility company and they said, okay, no more, you're done, you do have the option to go to the Public Utility Commission to request an arrangement. You do have to be if you're a current customer, so that means you've had service. So being a current customer means that either your service is on and bill's in your name, or your service was terminated less than 30 days ago. If your service was terminated more than 30 days ago, then you are an applicant. You are not a customer. And so you lose a bunch of those protections if you've been off for more than 30 days. So if you're under 150% of federal poverty, you will get one 60-month payment arrangement from the commission. And to do that, you can make an informal complaint. We have that information at the end, that contact information. It's very straightforward. It's either a phone call or there's an online form. It's a very accessible process. And again, if you've been off for more than 30 days and you're trying to reconnect at the same address, you can get one restoration payment arrangement that will give you basically one 24-month arrangement. And so then the Public Utility Commission is going to say 1/24th of your bill is, X amount. That's what you need to pay to get on. And then you're on that payment arrangement for the next 24 months. There are some issues with commission payment arrangements, why they don't work for everyone. Again, we'll talk about the customer assistance programs in detail later, but if you have already been in a customer assistance program and fell behind on those payments, which does happen, they are more affordable, but they're not, they're not perfect. So you cannot, I'm gonna say you can't. The commission will not give you a payment arrangement on debt that you accrued while you were in a discount program. However, the amount you need to get back on or to avoid termination might be much less than what's on the actual notice, because the notice might have your whole account balance on there, anything you've ever owed to them. Whereas there might, if you were only behind 2 or 3 CAT payments, that might be something you could do. So again, this is communication with the utility company to see is there a lesser amount they would accept. And then again, like I said, the commission can issue a payment arrangement on non-cap portions of debt, but often they don't. Typically, if you have any cap debt in there at all, they're just not going to give you a payment arrangement on that debt, which means you have to find a way to pay it, grant assistance for it. It's tough. There's not much else to do there. Again, other reasons. So the commission cannot require a utility to enter a second arrangement unless there's been a serious change in income or some other significant change in circumstances. So if you had one a year ago and your life has changed significantly, it's worth going back to the commission and telling them kind of where you're at now. They cannot extend an initial payment arrangement, again, absent a significant change in circumstances. And then bankruptcy. Utility debt can be discharged in bankruptcy. But you can still accrue new debt after that initial debt is discharged. If you've gone through a bankruptcy and you're still making payments on that agreement, even if you're completely up to date on that bankruptcy agreement, the commission is not going to provide a payment arrangement for new debt. I don't really like this rule. I don't particularly understand it, but they just have said, we're just going to knock it in the middle of a bankruptcy. So as long as you're still making bankruptcy payments, then, we're just not going to touch anything, even with the new debt. So complaints. This could be, so first you do have to attempt to resolve the dispute with the utility. So you get a shut off notice. You're like, well, I can't pay that whole amount. Call the company first and say, is there a lesser amount you all would accept to maintain service? How far behind am I on a payment arrangement? How far behind am I on my my customer assistant payments? If you can't get anywhere with them, then you can file an informal complaint. That's the phone number. With the Public Utility Commission, that's the Bureau of Consumer Services, BCS. You can call them. You can have a conversation with an investigator, and they will open a complaint for you. You will get a decision. It should be within 30 days. Basically, they take your information, then they reach out to the utility company, and then they come up with a decision. If you don't like the decision that you got, you have the right to appeal, which means you're filing a formal complaint. Again, that process is not particularly onerous. The form is not that much more complicated than the initial complaint. It's absolutely doable. And that, at the very least, that can buy you a lot of time because it can take a while to schedule those. Oftentimes, you will then end up in mediation with the utility company, which is good because you are then going to be talking to someone that has a lot of authority to make decisions. So, I really encourage people to take advantage of the complaint process, take advantage of the formal complaint process. As long as you have filed the complaint before your service is off, you cannot get shut off for past debt as long as that complaint is pending. But again, it's very, very important to do your best if you have a pending complaint to pay the ongoing bills. Again, it may not be perfect, but sometimes those are just fundamentally not affordable. But making a payment every month, even if it's not the whole amount, goes a long way, especially, I think, with the Public Utility Commission when they're determining whether you should get another arrangement. So any questions on any of that before we move on to tenants specifically?
There is a broader policy question. Do you want to address that now?
Yeah, why not?
Okay.
I hope I have an answer.
Okay, so this question is asking about the current administration's steps to alter some of these programs' operations, laying off federal staff, seeking to defund the weatherization assistance program.
Yeah.
How do these shifts in federal resources impact the protections and tenants' rights to access utility affordability? And are there actions in Pennsylvania to combat some of these changes at the federal government?
That's a really great question. So we saw that with LIHEAP this year. We weren't sure if LIHEAP was happening at all. It was kind of, in my opinion, it's kind of a miracle that it did. It did end up opening late. So it was delayed about a month. And in that month, we specifically were working with the utility companies directly and the Public Utility Commission to really encourage basically an earlier moratorium start date. So typically it would start December 1. We were like, well, LIHEAP is supposed to open, November 1, and it's not opening. So, people rely on those funds to, keep service on throughout the year. So, and we were able to get the utility companies on board to sort of start the moratorium, essentially start it early, because we didn't really know what was going to happen with LIHEAP. I will say it's scary. It makes our clients certainly incredibly anxious. LIHEAP specifically, which is the main source of assistance for heating, for energy and water heat, people rely on that all year. Like it's depending on how much you get, and if you're on a fairly low bill because you're enrolled in a program, that can last a long time. And without those funds, I don't know. People cannot afford their bills without those funds. I mean, that is just absolutely the case. A lot of people can't afford those bills even with those funds. So yeah, it is a very scary thing. There is, if you want to, it's like any other policy thing, right? Like I think you as a citizen of this state, as a citizen of your country, if you want to, let your elected officials know how you feel about something, that is absolutely your right to do that. And I encourage that. I mean, these programs are absolutely necessary. And it's really, really scary. LIHEAP's been around since 1980. It's changed a lot in that time, but it has existed as an assistance program since 1980. And so it is very baked into sort of how programs are designed, how rate increases are evaluated. It's sort of built into everything. And the idea of having that pulled away is very, very scary. So I don't know if that's a great answer, but yeah, that's where we're at.
No, that's a good answer. And there's a follow-up question about
Sure.
if there's any actions that we can take at the state level to address specific access to and to overall utility safety nets.
Call your state rep. That's always my advice, is call your state rep. And also on the last page of this PowerPoint does have a QR code on it. So we have a newsletter. So we don't send out a ton of things, but we do send out when there are proceedings coming up that people can get in, when the public can get involved. So for example, People's Gas is currently in a rate, and I'm only picking on them because I live in Pittsburgh. People's Gas is currently in the middle of a rate case. So next week, there are several public input hearings sort of on the western side of the state. And those are an opportunity for customers of the utility to talk directly to the utility and the judges who are in charge of those cases to basically explain what a rate increase would mean for them and their family. So we do some training on public input hearings. We obviously can't tell you what to say. I mean, it's your testimony, so you just talk, what it feels like to you. But we do have some information on basics around like what to expect, what kind of information are they looking for, and that kind of stuff. So I'm happy to share that actually to Brittany. I'll connect her, and then if anyone does want to get involved, they're absolutely more than welcome to. And we keep people sort of up to date on what's happening with that kind of thing.
That sounds really great. One last question for you. It's regarding PJM and failure to properly plan for rapidly increasing electricity demands and what that means for vulnerable populations. And are there any plaintiffs in the Commonwealth filing suit against PJM or AI data centers regarding the harm that's done to vulnerable populations?
That is a great question, and I will say it is slightly above my pay grade. I will say with PJM, so basically this is sort of a good basic explainer. So half of when I talk about rate cases, that's basically talking about the distribution rate. So that's how much you're paying the utility to get the service from them to you. The actual energy, gas, electric, the actual energy itself is purchased on the wholesale market, and PJM is the wholesale place where our utility companies in this region are buying their electricity. And so that's the generation cost. That is a market cost. So that is not fixed. It's not fixed like the distribution rates are. That's what's set in the proceedings. Those things are the market. So when the market shifts or something happens with an auction, that stuff absolutely trickles down to you. So those prices are called the price to compare. And those change December 1 and June 1 every year. So if you've seen some talk about June 1, electric costs are going to go up on June 1. And it's because of the market. It's because the price to compare has increased, and that is a market cost. So, those prices are affected the same way, the prices for everything you pay are affected. So yeah, that's just sort of a brief overview. As far as the AI stuff, let me, or the data centers, let me ask, because we have done like some policy work in that area, but it's a little bit adjacent to me. So I don't want to speak out of turn on that, but that's definitely something I can circle back on.
All right, thanks so much. That's the end of our questions at present.
Great. Okay. I know I'm going fast, but I'm going to make sure Brittany has all this information so she can send it out to you. So, I am going quickly. I know I am going quickly. Just do your best to hang on. And again, we can always circle back with questions and you'll be able to find me. So tenants specifically, so just a little bit of an overview. So you can be, if you're in an apartment, a mobile home, or a freestanding home, you could be individually metered. So that means, there is one electric meter that is attached to just your apartment. You have a account with the utility company. You pay your electric bill directly. You're paying for what you use. that's generally better for the tenant, especially, and I think for the landlord too, because it's just something that they're not managing. But again, so if you're individually metered, you can absolutely have service in your own name and you're paying for what you use, period. The landlord could keep service in their name in an individually metered place. That's entirely up to them. That should all be explained in the lease of how how utility services are split up. But typically, if you're individually metered, you're probably going to have service in your name. Master meter just means when, I'll just use the example of an apartment building because that's just sort of easier. In an apartment building, there's one meter. So not each unit is not individually metered. There's one meter that is connected to the utility company's, input, and that's it. And in those cases, the landlord has a choice as to how they want to pass on that service to their tenants. If a building is master metered, you as the tenant cannot have service in your name, even if it's like a duplex. If there is one meter, that service has to be in the name of the landlord. And then they can pass that cost on to the tenant, either through rent, so it just gets included, you just raise the rent a little, it includes all those costs in one figure, or they can hire a sub-metering company to put on sub-meters, and then the tenants would get billed by the sub-metering company. Still, they are not customers of the utility company in that case, but they are ostensibly, if the sub-meters work, ostensibly only paying for what they're using. And then there's also ratio utility billing. That has come up a lot recently, and that is essentially where there's just a master meter, there aren't sub-meters, and the utility, the property owner, the landlord is splitting up utility costs basically however they want by a formula and passing it on to the customers. Or passing it on to the tenants. Those can be tough because it's hard to do. Well, we'll talk about that a little bit. It's hard to do that equitably across the board. It's just a complicated thing to do. So sub-metering. So basically the process here is there's a single utility-owned meter on the property. And again, this is for regulated utility companies. The landlord can install sub-meters to monitor usage per unit and then split the bills accordingly. So again, if the meters are working properly, then you should, as the tenant, be paying for what you use. There are some resale restrictions. So essentially, as the property owner, you can't profit on the passing on of utility service to your tenants. So you, as the property owner, may be paying a commercial rate, which is fine, but you cannot charge your tenants more than what they would be paying if they had their own account with the utility company. It's a very, very hard thing to sort of narrow down because then you're digging in the tariffs, which are these, very complicated documents. But essentially that is the rule, is that you're not, as the property owner, you're not allowed to profit off passing on that service to your tenants. And again, because there's not a direct relationship between the tenant and the utility company, that tenant doesn't have access to the payment plans, the customer assistance programs, or the specific consumer protections. And then for ratio utility billing, the bill is paid by the landlord directly to the utility company. So again, they probably a commercial account that they have directly with the utility company, and then they can pass the cost on to the tenants either by unit, by person, or by square foot. So per unit is certainly the simplest, just even across the board, but it's not necessarily going to be the most equitable. So per person is more equitable for water, because water usage is really so much more directly related to how many people are in the home. 4 people in the home are going to use a lot more water than 1 person in the home. It's just the way it works. Per square foot can be appropriate for electric and gas heating bills, because that's largely dependent on the size of the unit that needs heating, right? 4 people in the home doesn't mean that you're going to be using more gas, right? So that was, if you're in a utility billing situation as a landlord, you're trying to figure out what's the best way for me to pass these costs on that's fair, this is sort of our recommendation. But in Pennsylvania, there's very little criteria. So it's, it really is up to the landlord. I would say, because we're in the fair housing context, splitting things up equitably is probably best for protection for yourself as a property owner. Because, again, if you have someone who you know, you basically, you don't, you know, family size can be a protection, but, you know, if you are actually doing it per person, you're probably protecting yourself from that. So again, you know, I'm with legal aid, so we're not really in the business of giving advice to landlords, but just, you know, you're protecting yourself, I think, by doing it as equitably as possible. And this would sort of be how it would, you know, be sort of equitable. I still think it's best if it can be individually metered, but I realize that is not, you know, that's not financially feasible for a lot of buildings, for a lot of situations. One other specific protection is called foreign load. So this is in the case that, so the tenant does have an account with the utility company, they have a meter, but because of, you know, either a meter twist or mix up or something, they're paying for service that isn't just their unit. So that would mean that like a shared washer and dryer would be running through the one tenant's meter. That's not permitted. So, and it's very common. It doesn't necessarily mean that someone is doing something nefarious. It's just, it's common, especially in old houses that have been converted to individual units. The wiring can be very complicated. If the tenant suspects that they're being charged for a foreign load, like their usage, their bill doesn't really seem to line up with what they're actually using, they can contact the utility directly to request a foreign load investigation. The utility should send someone out. If they find a foreign load, the utility company has to transfer service and any existing balance on the account into the landlord's name. This is not optional for the utility. It is a law. They must do it. The landlord is then held responsible for the full bill for that residence until they remove the load from the tenant's meter. So if it's a quick fix, it could be a quick fix, but essentially a tenant should not be paying for service that is not directly to their unit, if they are a customer of the utility company. And then the tenant would only be responsible for the utility bills going forward after the foreign load issue is resolved. So again, the utility company must transfer service and any existing balance on the account into the landlord's name, not optional. And the landlord is responsible for that bill until they remove the load from the tenant's meter. And then the tenant's going to be responsible from that point forward. But the past debt is going to stay into the landlord's name. And then a couple of other things. So these are two different laws that basically have the same protection. One, I apologize. One on the left there, DSLPA applies to regulated utility companies, and USTRA, Utility Service Tenants Rights Act, applies to everyone else. So this is one of those rare protections that applies across the board in Pennsylvania. I will say a lot of boroughs and smaller co-ops may not really be aware that this is out there that applies to them, but it does. Essentially, it means that if utility is in the landlord's name, and the landlord does not pay it, the tenant has to be notified of the landlord's debt 30 days prior to termination. So it's a different termination process. They have to be given an opportunity to pay the last 30 days usage charges, and then they have to be given that opportunity every month in order to maintain service. So they can put service in their name. They have the option to do that if they want to under these rules, but they don't have to. And with a lot of smaller water, they may not be able to. Like a lot of boroughs, just if you're not the property owner, you cannot have service in your name. So you don't need to, but it is an option. But essentially, to maintain service, all you have to be able to do is pay your current ongoing charges. You are permitted to deduct that from rent, and you cannot be held responsible for the debt of the landlord. That said, so if if the tenant is responsible for, reimbursing the landlord for those bills, which is very common, and the tenant doesn't do that, the landlord has the right to pursue an eviction because the tenant is in violation of their lease agreement. What they do not have the right to do is any sort of self-help eviction and turn off service or anything like that, right? Like the proper remedy for that is through the eviction process. It's not through a self-help eviction. And to that, like if the landlord physically turns off service, which we certainly do see, disconnecting a breaker, shutting water off, that is likely going to be a constructive eviction. And that we would certainly recommend that the tenant reach out to a landlord-tenant attorney. And similarly, a landlord or owner can't request can't call the utility company and say, hey, shut off service here without providing notarized consent unless there's some sort of emergency. So the tenant has to be given notice and ability to keep service on going forward by paying just those usage charges every month. And if service gets shut off accidentally, which happens, it doesn't happen a ton with the regulated companies, but it does happen. If that happens, the utility company should restore service right away, and then give the proper notice. Oftentimes when it happens, it's simply because they don't have the unit marked as tenant occupied. They may have it as owner occupied, and that happens a lot as more places are sort of becoming rentals. So it's not uncommon, but at least with the regulated utility companies, these rules are pretty clear. For the boroughs, municipalities, things like that, you may want to, we'll give you some more referrals at the end, but definitely first call is to your local legal aid. Any questions on any of that before I run through the assistance programs? We're going to do that pretty quick.
There are two quick questions. So first off, is there any consideration within the regulatory agencies for aging and outdated appliances regarding the costs? So these old and struggling HVAC systems where you're a renter and you don't have any responsibility for replacing these high ticket items yourself.
That's a great question. And we're going to talk about that when we talk about weatherization in about 2 minutes here. So yes, we will get there, but very good question.
Second question, is the sub-metering, does that work for water as well as other utilities?
I would say it's rare, but yeah. Typically, water's a little weird only because the idea of having large investor-owned utility water providers is relatively new. It used to be that you got your water from your, that's your city government's, part of the services that they provide. So the structure for those programs versus other programs is really different, and a lot of the rules are different. So, because a lot of municipalities have lien authority, meaning if you fall behind on your water or sewer debt, they can place a lien on your home. For that reason, a lot of property owners and landlords that are renting out properties want to keep that service in their name. In which case, it doesn't really matter if it's master metered or not, because it's in their best interest to make sure that their property isn't getting liened. But so I think you do see master metering probably more with water than with anything else. And again, to split that up, I don't know how common sub-metering is with water. I have to assume it's less common, but I don't actually know that. As in, water is just sort of kind of a weird, it's way more likely for you as a tenant to not be responsible for your water bill, or you're paying that, to your landlord, but it's more common, I think, to not have that service in your name. Sorry if that's not really helpful, but.
No, that's great. One additional question came in regarding utility termination. So what if the property management company or the owner does not get the full 30-day notice before the termination?
So the property owner the owner is supposed to actually get a 37-day notice, and then the tenant is supposed to get the 30-day notice. So it basically gives both the landlord and the tenant the opportunity to pay to maintain service within a reasonable time frame. But that, again, this only applies if the landlord is responsible for the bill, if it's the bill is in their name and it's their account.
Okay. All right. I see we are just about at 1 o'clock. I'm able to keep the meeting open a little longer if folks have a little extra time, and if Lauren, you have some extra time, or we can close it off and share the rest of the information via email. What's your preference, Lauren?
I actually do have a 1 o'clock. I am sorry that I kind of went a little long, but let me just flip through. I just want to show you. Again, there weren't that many more slides, but I just wanted to make clear here on the last couple of slides that we do have, contact information for specific complaints, specific issues. So just keep those in mind. And then I'm going to throw this up there. So this is so if anyone who's interested, if they want to take a slide or take a photo of this, that'll connect you to our newsletter, so we can keep you sort of up to date with what's going on. You can always email us at pulp at pautilitylawproject.org. That goes to everyone. And so if you have a technical assistance issue, that is definitely the place to go. Someone will absolutely get back to you in a timely manner. It might be a day, but it's, it won't be weeks. So I will leave it there. But again, if there are other things that come up that we want to talk about, And I'm sorry about the weatherization stuff. But I do also have a 1 o'clock, and I apologize for rambling a little long. But
No, thank you so
essentially,
much for
yeah,
this great information. There was so much included in there. I will send out all of these slides, all of the information,
great.
any resources Lauren would like to share. We will
Yeah,
get it out
I'll
to
circle back
everyone.
with you, Brittany. And the one thing I would say too, if you're a tenant and you're dealing with like outdated appliances, heating systems, stuff like that, call your electric and or your gas company, because they do have programs for low income households to do a fair amount of repair. So that would be call number one. Call the utility company, see what they have available, because they may have a program for you that can help provide some efficiency and weatherization, appliance repair, replacement without without any expense to the tenant.
Okay. Well, thank you again, Lauren. Thank you everyone for attending. We will send out all this information. We'll send out the recording and look forward to having you join us next month for our next
Great.
Fair Housing and Power Hour session. Take care,
Thank you
everybody.
guys so much.
Bye.